Thank you. So just by way of a little background of my own history, before joining the Segal Group, I worked for almost 20 years with the Department of Labor in the Employee Benefit Security Administration in the office that really worked on the guidance and the early implementation work around the Mental Health Parity Act. So it's a law that's near and dear to me. And then in the past 2 years, I have shifted to a consulting role, and I'm working with large employers mostly, all different types, insured, self-funded, but really working with those employers to ensure that they are complying with the law, but also as they look towards and echoing the discussions many of you probably participated in this morning, employers having an ongoing eye towards how they can provide better and more comprehensive mental health and substance use disorder benefits. So doing that and doing it in compliance, is a great effort, and it includes some challenges. And so we have this amazing panel here today that I'm honored to sit with, and look forward to talking about, some of the ways we can continue to move forward with this important law and the protections it provides. So with that said, we're going to get right into questions. We have an individual question for each of our panelists. Then we have a few questions that they can kind of chime in as they would like to share their insights. And then, as Joe mentioned, we'll look forward to opening it up to questions that you all may have around these issues. So with that, our first question is for Colleen. As you heard, she's with the Department of Labor, the Office of Enforcement. As most of us in the room probably read, the 2018 report to Congress came out where DOL really introduced increased an ongoing focus on enforcement around the parity rules and announced mental health parity specialists and an opioid task force. And so, we're pleased to see all of that information. In 2016 and in 2017, we had seen enforcement fact sheets that gave us a little snapshot of what the department was seeing in terms of compliance problems, in terms of the work they were doing in enforcement. So we haven't seen something like that yet. And Colleen, we're very interested to hear with the new initiatives underway, sort of what's going on in the program and where you might still be seeing plans and employers falling short of compliance.
Okay. Thanks, Elena. So just a quick introduction for, as far as who I am and my perspective. Before I get into the question, I've been working for the Department of Labor for about 12 years, and prior to my current position in the Office of Enforcement, I worked in the regional office in the field doing investigations as an investigator and as a senior advisor for health investigations. So I've been in enforcement the whole time, and so I have a certain perspective with regards to mental health parity and mental health issues within plans generally. But I would say that I've always felt very inspired to work on these issues in my cases, and I'm really excited and grateful that I can work this issue and sort of bring it to the next level in my new role. So with regards to the fiscal year 18 enforcement fact sheet, it's not out yet, and I can't really say anything about it because it's not public yet. I'm told it should be very soon, so it's in clearance. But just to give a brief background on the previous ones that Elena mentioned, we do put out annually since 2016, 16 and 17. Enforcement fact sheet that gets into statistics about our mental health parity cases, tells you all the number of cases that we've had where we cited violations, the number of violations, and then also gives some background, a few examples, and these are actual case examples where we found issues and what compliance steps that we had the plans take to correct the issues. So, but with regards to that, the last fact sheet in 17, if you did take a look at it, you would see that NQTLs were the largest percentage where we found violations. So to answer your question about where we are still seeing issues, I would say very largely in the NQTL space. And then also not specific to parity, but with regards to enforcement relating to just mental health, I would say we also see a significant lack of access to the appropriate treatment. So I believe one of the speakers this morning mentioned about MAT, medically assisted treatment, as a gold standard for opioid treatment, and yet we see many plans that have blanket exclusions of this and other medically necessary treatments. So as far as issues that we're still seeing, those are pretty high up there. With NQTLs, it's all over the board. I would say largely in the first couple of years of really digging in and reviewing parity for enforcement, we saw a lot of the pre-authorization requirements was sort of the lower hanging fruit. That was one that is very obvious in the plan documents. But as we've sort of moved through a lot of those and kind of gotten rid of a lot of those, and employers becoming aware of sort of what they have to do to analyze whether or not it's appropriate, it's really the utilization review and the things embedded in things like, like I said, the utilization review and also the medical necessity criteria guidelines, and the other review process that employers or plans require the participants to go through in order to seek mental health treatment. As far as our efforts, the largest, I think, push for us is to try and make global scale corrections. So while we do have authority and jurisdiction over the private employer plans, we also can investigate and look into service providers of these plans. So we have tried to push enforcement up a level so that if we're seeing issues at the employer level that we are seeing over and over again and they're using prototype plans, we then go to the next level and talk to the ASO provider, the TPA that's providing the services, to see if really the change needs to happen at a higher level. So as a result, we may have fewer cases, maybe even fewer violations cited, but we're really striving for deeper impact. So we may make a correction at a service provider level that will impact hundreds, thousands of plans, instead of going plan by plan and trying to get each one. We're also making coordinated efforts with the states and with HHS. We've been reaching out in many cases on specific enforcement matters, but then also just trying to communicate and make sure that the analysis that we're going through is similar. With regards to opioids specifically, we are also, a lot of our regional offices, like Elena mentioned, I think, but we have senior advisors in each office, and in the regions, those senior advisors are reaching out with SAMHSA to talk to providers like doctors to inquire about what are the problems that they are seeing when trying to get treatment for their patients. And that gives us a clue as to where to look when we are looking at a plan or a service provider. So I think that we have made some headway, but we definitely have a long way to go towards compliance and getting what it was truly envisioned by the statute.
Thank you, Colleen. That was a great segue, because now we're going to talk to Todd Pearson, who joins us from Aetna. And as we know, Aetna works both as an insurer and provides services as a third-party administrator to many plans. Some of us may have seen there was a recent sort of highly publicized Pennsylvania Department of Insurance investigation that talked about some mental health issues that were identified in a look at Aetna. And we know there are challenges with compliance. So we'd love to hear, Todd, sort of how you're navigating those challenges to ensure parity compliance and how you're working with your members to help them be able to ensure that compliance as well.
Good afternoon, everyone. It's really a pleasure to be with you all. By way of just really quick background and my point of view, I am in-house counsel for our behavioral health benefit, which includes ZAP. I've been with Aetna for 3.5 years now, and some other roles that's probably worth mentioning is support of our high deductible health plans, which tends to weave through conversations already had today, as well as working on things related to the ACA like medical loss ratio. So prior to joining Aetna, I was actually a Navy nurse for 8 years, stationed in a variety of settings, inpatient and outpatient, anything from taking care of detainees to running a primary care clinic. So I've seen even firsthand what it means to have challenges with access, what it means to coordinate care, and I really enjoy the opportunity to bring those perspectives to my day-to-day work. To your question, I think as it relates to the Pennsylvania Market Conduct Exam, or really any finding for that matter, excuse me, I'd start by saying it's important, I think, for everyone to just remember the timeline of kind of parity and how that plays into a variety of findings that might make the headlines even today. So not news to anyone in this room, parity as a law was passed in 2008. The final rule itself became effective for plans starting July of 2014. So really, in essence, the majority of plans being calendar year plans really became in scope for the final tri-agency's interpretation of the law effective for those 2015 plans. So relative to even to the Pennsylvania Market Conduct Exam, just like some of the more recent things that Aetna or a variety of other carriers have experienced, that exam itself even encompassed plan years starting in 16 and 17. So the first point I would make to, I think, the audience is where our perspective is on parity, and I would suggest even the industry's perspective on parity, is today is a lot different than where it was in 2015 and 2016. And in particular, backing up from very specific findings of the Pennsylvania Market Conduct Exam that are nuanced to fully insured business, the takeaways that I think are important for this group is to understand that some of the challenges that Aetna or any other carrier for that matter has relative to trying to do our best to fully realize parity and be compliant with parity are best fleshed out even by way of exams. I really think of exams as your fourth leg of a stool, in essence, to a full understanding of the iteration of parity, right? Your first leg of that stool would, of course, be the law. Your second leg of that would be regulation. Your third would be all the sub-regulatory guidance. And your fourth oftentimes can be the actual enforcement actions that either state or federal regulators do. And such was the case in our Pennsylvania Market Conduct Exam. At issue for many of the objections that became even public, at the heart of it is a benefit classification issue. And, there are, not to get into the deep substance of parity, but, there are a slice of benefits that have applications and medical necessity purposes both in the medical space as well as the behavioral health space. And that became a central theme of that exam. And what the application, I guess, that I would encourage the audience to think about as you interact with your carrier as a TPA is, number one, just having a full understanding of their comparability analysis. And that even fundamentally starts with the way they classify benefits. You as a sponsor of a self-funded plan are always free, obviously, to deviate from benefit classifications. But the lesson learned that I would hope things like the Pennsylvania Market Conduct Exam would teach an audience such as this is it's imperative that you work hand in hand with your administrator to really understand their full comparability analysis and ask those questions. And transparency vis-a-vis self-funded plan sponsors and their TPAs only progresses parity compliance. And the last point I would even make relative to kind of findings at large is there's a lot of action as of late with state houses, state legislatures obviously passing their own variety of parity legislation. Notably here in Illinois, a very robust law was passed. And I think that is actually a win-win for everyone that sits around the parity table. Transparency in the way that carriers, TPAs think about parity, our comparability analysis, being open and transparent to not just our plans, but our members, and in particular to our members in ways that are understandable, only advances parity for us all. So, the theme and the takeaway I would say relative to any exam for this group is to really understand where your carrier sits with their comparability analysis in a written way. Ask them. Provide me with the documentation that you keep around your comparability analysis.
Thank you, Todd. I think that's great advice. So now, we've talked a little bit about the challenges. I think we all know that there are some areas where there's still a little absence of clear guidance as to how the parity rules apply to certain designs, certain situations. Yet we see this increased state and federal enforcement of the law, and we see an increased interest by employers of providing comprehensive quality mental health and substance use disorder benefits. So I think we all share an interest in not seeing parity become something that would in any way prevent employers from continuing to cover mental health and substance use disorder benefits or holding them back from advancing their efforts to expand and provide greater and more quality benefits. So on the backdrop of all that, I think employers and plans are really looking for ways, and insurers, ways to help them comply. So Kevin, can you talk to us a little bit about your accreditation work and how that helps advance those efforts?
Sure. Nice to see everybody. My name is Kevin Malone, and I'm the director of the Parity Accreditation and Compliance Support work at the ClearHealth Quality Institute. That's one of my roles. I'm also a senior counsel at Epstein, Becker & Green, a healthcare specialty law firm based in our DC office. And in my private practice, I work with health plans, trade associations, medical specialty societies, and providers on a wide range of coverage and payment issues, including parity. And before I came into practice, I served for 6 years in the Department of Health and Human Services, 3 years at CMS, and 3 years at SAMHSA, where I worked on the sort of early versions of the commercial market rule. And then at CMS, I helped on the early versions of the Medicaid parity rule. And so I've had the opportunity to sort of serve as a health plan regulator, work on sort of behavioral health quality improvement and access initiatives as a public servant. And in my practice, I've helped plans respond to market conduct exams, build their own compliance programs, and also help states in their oversight activities and providers in their negotiations with plans that are relevant for parity. And I've tried to bring all of that experience to my work with CHQI to build not only an accreditation program, but also some technical resources for TPAs and insurers to help build compliance programs. And I think really the biggest, really sort of the biggest gap in sort of parity enforcement and compliance activity to date is not really anyone's fault. It's that the tools that are in the hands of enforcement agencies and regulators and plaintiffs are related to taking sort of snapshots of plan conduct, sort of specific benefits to ensure, like, are they compliant at this moment in time? And what we've tried to do at CHQI is to look at it from really more of a compliance program perspective, in the sense that for a plan that were to apply for accreditation through CHQI, what we're seeking to do is assess that entity's capacity, their policies, procedures to comply with parity, as well as their factual compliance with parity in the present moment. And that really transforms things in the sense that, from my personal perspective, I think parity, and in my practice this is borne out, there's really sort of two pathways that we can go down. One is that it is going to be a highly sort of regimented, sort of very like document-heavy, very cost-intensive process for health plans and administrators to demonstrate compliance without really any meaningful change with regards to access or quality. And on the other hand, there's an opportunity for parity to really activate the entire behavioral health system towards managing behavioral health services based on quality and based on evidence-based standards, and integrating behavioral health into the overall benefit design. And the online tool that CHQI has developed, which is the first ever piece of enterprise software that's specifically designed for health plans to use in managing their parity compliance programs, is intended to sort of facilitate the better outcome and not the worse outcome. In the sense, in my practice, I've engaged with, behavioral health counsel, not Todd, and behavioral health medical management directors who have, because of fear of parity enforcement or parity liability, are really holding back in taking steps to improve quality and improve access on the behavioral health side, because they are afraid that they are going to inadvertently cause a parity violation because they're doing something specifically for behavioral health that could be seen as an NQTL on paper, even though their intentions are to deal with quality issues in the provider community. Some of the discussion this morning was around using value-based payment initiatives for behavioral health. There's a real world where you implement a value-based payment program specifically for behavioral health benefits that you're not implementing for medical surgical benefits, and even though you're trying to pay for quality on behavioral health, you may have violated parity because you're implementing something on the behavioral health side that you're not doing on the med-surg side. And so what we at CHQI are trying to do is to prevent that from happening, to provide some tools for health plans to facilitate the integration across the enterprise such that the sort of core aspects of parity, which is communication across benefit management, communication of functions that are doing the same types of activity on the behavioral health side and the medical surgical side, including using vendors, is sort of streamlined so that that process really sort of can just be integrated into the day-to-day workflows of people that work at health plans. And probably the hardest thing about parity for health plans is that it requires a level of interdepartmental and sometimes inter-company collaboration in day-to-day decision-making and business processes, even at like the epistemological level, that has just never been the case before. And that requires a cultural change, that requires, and I know, Todd, you probably more than anybody I've ever talked to, are living that every day. And so what we're trying to do at CHQI is to provide some technology and outside solutions to ensure that plans that are accredited are doing that, and that they have some technology solutions to help make that possible. And the one last thing I'll say that is particularly for the employer and regulator audience is that the online tool that we're using is also intended to reduce the burden associated with exams and audits, including internal audits, by providing basically a touch-of-the-button report of existing existing operations across the entire benefit and all NQTL types that can demonstrate, with a click, a report that will show parity compliance that employers can solicit, that regulators can use in lieu of a market conduct exam. And having spent time as outside counsel, a lot of time and money, helping plans sort of prepare and respond to market conduct exams and go back and forth with state regulators or DOL, having sort of an opportunity to just create a snapshot that can produce a report that's responsive about every NQTL has tremendous potential for getting everybody back to delivering care. So that's the goal.
Thank you, Kevin. Very well stated. So now we'll move on to some questions for everyone to chime in as you would like. So I think this is a very versed audience, but the word NQTL, non-quantitative treatment limitation, has been flying around. If anybody slightly new to this topic is here, we're thinking of things like pre-authorization requirements, and as Colleen mentioned, utilization management really is where you land when you take a deeper dive. There are areas such as that where the test ultimately is for a plan or insurer to be pointing towards the evidentiary standards, the factors, the sources that were relied upon that ultimately support whatever NQTL is being applied. I think there still remains a lot of questions as to how to identify those. And so we wondered if folks on this panel who are sort of deeply entrenched in dealing with these issues have some advice as to how to maybe proactively comply around the issue of NQTL compliance.
Okay, I'll start. Proactively comply. I think from my perspective to employer groups out there would be a responsible fiduciary. Know and understand the benefits that you're offering your employees. Ask questions to your service providers about their processes of how they're going to process claims. What is the utilization management, utilization review process? Look into the medical necessity criteria. And I know that sounds like a lot because you basically feel like I hired this service provider to do this work for me. But if you're hearing from me, then you're still on the hook. You still are on the hook as a fiduciary, and you are still responsible to monitor your service providers and to ensure that your plan is in compliance. And the service providers there, yes, can help you along the way, but to be proactive would be to ask these questions ahead of time, to ask your service providers about their NQTLs and what analysis they have done, to see if there's documentation, as Todd had mentioned before, to get that up front. If you're hearing from me or from anyone in enforcement, it's likely because we have identified some sort of issue and are asking you specific questions about that. So you should also expect from us that we're going to want, if we do identify a problem that we think is a violation, that we're not going to just want prospective correction, but retro correction, and that to ensure that the people who have been harmed in the past, the participants that are affected, are made whole. But I would say just know what you really have and what your employees go through in order to get their treatment. Understand that.
Yeah, well said. I would add to that, I'd back up just for a second to say, I think it's also important to understand what are the routine governance practices that your administrator has in place that continually serve to evaluate parity, right? So Aetna, probably similar to many other behavioral health administrators, has a routine standing group called the Parity Task Force. Just internally, that's our name, right? A multidisciplinary group of compliance professionals, legal, clinicians, operations experts that on a routine basis talk to each other about what our benefit design looks like, what challenges we're seeing to that, touching up our comparability analysis, and it is a life cycle of continuous work on our comparability analysis. So I think even before one gets to the discrete answer of how does my administrator address prior authorization or concurrent review, I think you also want to ask yourself, what do they do on a routine basis to continually work on parity compliance? I think as it relates specifically to what oftentimes can be the ambiguity of dealing with factors, evidentiary standards, and the like, I think one of the things that is a benefit for an organization, for an employer, is to literally, read the comparability analysis that's provided from your administrator. And you have the perfect perspective to read that. It is from a consumer perspective of, I'm not a parity expert, so when I look through this, does it actually make sense to me? Can I understand why these services on the medical side are subject to prior authorization, whereas these services on the behavioral health side are subject to prior authorization? Just a natural, inquisitive mind as to reading a document and saying, does this actually make sense to me? That is, I think, the point of view that oftentimes even a regulator comes from. Can I read this analysis and actually make sense on why a TPA or a carrier is saying there's comparability in these benefits? That natural perspective, I think, has gone a long way even for an Aetna of the world. I think about where we were with some of our benefit plan designs back when parity was passed in 2008 compared to now. If you're looking at our fully insured book of business, we've gone from upwards of 14 of our benefits in the outpatient category. And outpatient other is a term of parity art, but I'm talking about not like your office visit things, but things like partial hospitalization or IOP, those type of quasi-inpatient, outpatient services. 14 of those benefits, when parity was passed, were subject to practices. And if you look ahead to even now, we have a list of 3 that are on our national pre-certification list. And that's a direct byproduct of us continually refining our process, of the work of the Parity Task Force to take their time and say, does this analysis actually make sense, and go from there. And the last thing I would say too, this is maybe beyond your question, and I won't go too long on it because we might come back to it, but I think it's also important to ask your administrator, what are the innovations and the things that you're doing beyond parity? Because if you really look at the true essence of parity, parity just says your behavioral health benefit needs to be as good as your medical, right? It doesn't say, what are you doing to advance your benefit to a place where it needs to be, right? In theory, one could have a particular benefit design or particular programming that's problematic for medical and equally problematic for behavioral health. And in theory, you don't have a parity issue, right? They're both pretty lousy, right? But what I think it's important to ask your administrator is, beyond parity, what are innovations you're doing to advance our behavioral health benefit to best address the needs of my employees?
So I think from the employer perspective, in addition to the great comments that we've heard already, I think that I want to reiterate something that Todd said about sort of really focusing your questions on the governance of the parity compliance program at your third-party administrator or carrier, because it's accurate to say that it's unrealistic, or it's potentially more than anybody wants to bite off to engage in the sort of detailed comprehensive assessment of all the factor sources, evidentiary standards, et cetera, for every non-quantitative treatment limit that your TPA is administering. But what you can do is ask very sort of detailed questions about the way in which the parity compliance program is being implemented across the enterprise at your vendor. And that's one of the things that we're hoping the CHQI accreditation will help validate. But even without that, that's a set of discussions and questions that you can have. And I think the carriers that are really taking parity seriously will have a very detailed and comprehensive answer to provide to you. They'll have documentation about the training that they're providing for their staff, about the frequency of which that parity compliance oversight governance process functions. And the other thing that I would add to what my colleagues have said is really about outcomes data. So the NQTL comparability and stringency test is both a disparate, it includes a disparate impact provision. Basically, the analysis requires the review of the comparability and stringency as in writing and in operation. And that in operation phase is where I think we as a society have the greatest opportunity of taking parity from sort of like a paperwork activity, where we're sort of producing a large volume of policies and procedures that sort of validate and substantiate things that were already happening, and take a focus on sort of what are the substantive outcomes of these medical management strategies on the quality and access to care that patients actually experience. And a lot of these, because of the way in which enforcement works, it has to involve both. You know, looking at the way policies are developed, the documentation that supports that. But I think as employers, there's a real opportunity to keep the focus on the outcomes. You know, like you have flexibility to decide what the priorities are for you about what parity oversight and compliance looks like. And you can decide what, with regards to comparing mental health and substance use disorder, sort of access and quality and denial rate and other sort of issues that you experience from an outcomes basis, that's going to be a better use of your time, in my opinion, in overseeing your vendors than sort of really trying to roll up your sleeves and dig into you know, the sort of evidentiary standards that they're using and deciding whether or not to you know, apply exclusions in one category or the other. So that's my my recommendation.
So, and Kevin, just to tell me if I'm characterizing your response right, but I feel like what you're kind of describing is a scenario where a plan, an employer the outcomes are the factor that's driving how they're managing some of the things. So if they're looking for positive health outcomes supported by clinically appropriate medical evidence, and that got them to the way they manage benefits, that may be their answer. That's exactly right.
Yeah, I think that you know, one of the challenges and the opportunity that parity presents is that it can catalyze sort of across the whole benefit transition towards managing on outcomes, right? Because if you manage, reimburse, and you know, contract and implement all of your NQTLs on sort of comparable outcomes metrics, that's going to be a parity compliant approach, and that's going to take sort of a cultural change that we all have to go through together.
Todd, you
Yeah,
want to
if I could, great thoughts. Specific to outcomes, I think I don't disagree with what Kevin's saying. I just want to make sure that when looking out outcomes, one is thinking about them in the proper balance, right? So talking to a educated group, I'm sure you're familiar with parity, but outcomes themselves are not de facto non-compliance, right? So I think they're good waymarks, right, to say to yourself, do I need to ask my administrator some deeper questions? But I would just caution you to not be too hyper-focused on outcomes and outcomes alone. I think outcomes in conjunction with, for instance, what does your governance say when you have disparate outcome results when looking at denial rates from your medical benefits to your behavioral health benefits? What action steps are taken? What internal experts are brought into that to evaluate what's going on is really a question that, to me, gets to even the spirit of parity, right? Because outcomes are actually, in a world where we are actually executing on legitimate, bona fide, evidence-based medical necessity criteria, outcomes will be driven by the actual presentation of our members. But what can present challenges is the notion of looking at my outcomes and being so hyper-focused on the outcomes that I might lose sight of what do I do when my outcomes, what does my administrator do when my outcomes start to look like they're going off the rail? Who do they talk to? What resources do they mobilize? What questions do they ask? I think are part of a complementary approach to looking at outcomes.
Yeah, that's well said.
Thank you.
Just to add on outcomes, as far as when we look at, you know, when we're doing an audit or investigation, our focus is sort of on the higher level of the policies, but we always look at outcomes because even if we're looking at the policies, we still want to do the operational review and see how is it actually playing out. Even if you have this policy that looks good, how did it play out? So we look at the outcomes for red flags, but then also we look at the outcomes, so we see a policy that maybe we think looks bad, and we look at the outcome and we see actually the outcome was beneficial for the mental health side. So it's not de facto, compliance or non-compliance, but it is more of a red flag indicator, I think, or a way to test how the policies and the compliance protocols are working.
Right, which is exactly what I was thinking in recommending for an employer audience to use them for that purpose, so sort of informing your review of the governance process and policies around parity compliance by a review of certain outcome metrics that really identify red flags and help make sure that you're working with your TPA to really change those metrics over time. It really can change the conversation from we're gonna flag you on the fact that you have you have 6 factors over for this NQTL and 3 factors over here, and they're not the exact same factors, and then you're fighting over paperwork, to really focusing on on substantive access, that everyone really can get behind.
That's great, and this is a great segue. We'll do one more question for the panel and then open it up to the audience because we are winding down on time. But I think, throughout this morning, other breakout sessions, in my work over the past couple years, really we continue to see this increased interest by employers. Employers have been facing the opioid epidemic, the challenges that come with that, and really this ongoing interest in providing more, better mental health and substance use disorder benefits and getting those benefits to their populations. So with that in mind, can each of you kind of tell us if you thought there was one area where we would really need or benefit from additional guidance as to how the parity rule works with respect to whatever particular area you name, so that, again, parity really won't become a barrier for employers trying to offer quality behavioral health benefits. So do you guys have sort of input onto where we still maybe need a little guidance?
So I can go first because I have many. Having gone through the experience with some folks in the audience, including and Utah as well, in developing sort of the first working draft of the accreditation standards to try to benchmark against all of the DOL and tri-agency guidance. I think one of the areas that I've struggled with the most, also in my private practice, is the definition of the NQTL type. So one of the hardest parts about parity compliance is that it requires the comparability of something that fits within 4 walls of what is that non-quantitative treatment limit. And that's relatively straightforward if you're talking about prior authorization or concurrent review. The sort of common understanding of those functions is relatively straightforward. There's not a lot of controversy about it. But the definition of what is a non-quantitative treatment limit is effectively all-encompassing. It's any limit on the scope or duration of a benefit that's not quantitative in nature. And as a result of that, plans, and this is really where a lot of the market conduct sort of back and forth breaks down, is where the plan has a good faith and possibly reasonable understanding of how they're organizing their functions into boxes of non-quantitative treatment limits for the purposes of their own internal analysis. But from an outside audience, that sort of arbitrary designation of what constitutes NQTL universe, especially around things like exclusions, could seem to be self-serving and expressly to avoid violating parity. And I think that some guidance around sort of what are the sort of fundamental principles of unity in function across classifications for the purposes of defining a non-quantitative treatment limitation type would be very helpful. I know that's an extremely technical answer, but I think about it all the time.
Yeah, great question. I think, from my perspective, a great benefit in terms of clarifying guidance would be around the level of supporting information that's needed to substantiate various non-quantitative treatment limits. And there are certain factors, is a very technical term that comes out of the final rule, but there are certain of these rationales, I'll call them, that I think naturally lend themselves to a qualitative explanation. By way of example, safety. Like if safety is a concern of mine on why Aetna chooses to limit the scope or duration of a benefit, there are, I think, very rigorous and what I would suggest satisfactory explanations of how we have experts that weigh in on this. They're non-biased experts. We bring in external folks. I think there is very qualitative and sufficient answers to those. I think in other instances there seems to be a growing disconnect in terms of other factors and what's needed to substantiate them. They could be factors such as high cost, and really like what depth of substantiation is needed to say the trigger of high cost is satisfied. Does that need to actually be reduced to specific dollars and cents? Is that still best explained qualitatively? That is a level, I think, of clarity that would be helpful for at least Aetna and perhaps others that administer behavioral health benefits.
And sorry, I just have to jump in here on this. One thing that, to Todd's point, that I think we should all think about as a community involved in sort of pushing parity compliance forward in the future is the trade-offs associated with how you move forward on a question of quantitative versus qualitative evidentiary standards, in the sense that there are certain consequences for what that means for the way in which benefits get managed in the future if you tie things down in one way or the other. And I don't necessarily know enough yet to say that, like, really tying people to a quantitative evidentiary standard expectation where it's conducive is going to have adverse consequences or not. But I think keeping our mind on the long-term goal of using parity as a tool to leverage system-wide advancement in managing towards quality outcomes and evidence-based standards of care. Like for me, I'm not entirely clear whether starting from a position of saying, quantitative evidentiary standards will help us get there, or it may actually do the opposite. And so I think that's I think a really live discussion that I think needs to be had.
And the game's on. Yeah, and I don't know, Colleen, I don't know if you have anything that you want to add to the discussion. I do know, to take Colleen slightly out of the hot seat, that some of these issues are things that the Enforcement Division needs to take back to the folks who work on policy issues, and issues continue to be worked on.
Right. So our agency does put out guidance, not necessarily enforcement for public consumption, but what we see in our investigations, what we hear when we're out at events like this, we do take back and work that into our technical guidance, be it FAQs or the like. So yeah, it's hard for me to say because it's our agency that puts guidance out. So as far as what guidance is needed is really to, I need to know that from you all.
But we appreciate that. We have an active ear here to carry that message back to the departments. And I think both hearing, whether it be that we hear at future guidance or whether it be that there's also information gleaned from future enforcement fact sheets that at least tells us the direction where the departments are going around these issues continues to be helpful for everyone trying to navigate it. So with that, maybe we'll open it up to questions if there's audience questions.
So I would go back to some of the points that I started in my intro as far as where we're going with enforcement. As far as penalties and whatnot, for us at DOL, when we do take an enforcement action, our biggest thing as far as the money would be getting affected claims paid. Is like that's the first thing. As far as penalties, we do have some penalty, but the first thing that we're concerned about would be getting claims paid for people who were affected. As far as going forward in what we're trying to do enforcement-wise, is what I mentioned, is trying to go a little bit more global. We're already doing this, and much of the correction, and I actually believe all of the corrections that we have received so far in mental health parity have been on a voluntary compliance level, and we do work with the issuers, with the ASOs, the TPAs, if it is at that level where the employer group, the Taft-Hartley plan, is unable to necessarily get the correction that they want from that service provider level. So we are working to have discussions with whoever that service provider is at that TPA-ASO level to try and get correction and then get broad correction, because it's not just your plan that's battling that. It may be if it's a prototype term, or even if it's just embedded in the process and in the policies, that we can change those policies and get it changed for many. Enforcement actions to the level that we do on these deep dives, if we're looking at the utilization and we're looking at the claims processing and we're looking at the policies and we're having back and forth with issuers, ASOs, TPAs, it is a long, lengthy process because it's a deep dive. And it does take some time to develop the case. And like I said, so far we've been able to work with those entities and get correction at a voluntary level, but we also have to collect all the evidence that would be needed if we were to litigate. And so that takes time to build a case. So I don't know 8 years, but it does take a couple of years at least to build a case that our attorneys would want to put forward. But I do think as far as what we're doing in the future is trying to hit a global scale, trying to talk and work with the issuers and the ASO client or ASO providers to get wide-span correction.
And I think I would want to just add something here, just from the general perspective, that one of the reasons why enforcement of parity is so challenging is that the U.S. healthcare coverage system is extremely fragmented. And parity is actually one of the most sweeping laws that we have in our country, in the way that it applies to almost every form of coverage except for Medicare and Medicaid fee-for-service. But because there are so many different healthcare delivery systems and benefit programs in the country, a multitude of different agencies and authorities at the federal and state level are tasked with doing enforcement. And so, DOL only has responsibility for the specific plans and entities that they have the mandate to enforce. Attorneys general, insurance commissioners, Medicaid agencies, CMS, HHS at the federal level, all have a role to play in enforcing parity for different plans in different parts of the market. And so the reason I say that is that our perspective at CHQI is that enforcement is never going to be strong enough to transform the system with regards to parity compliance. And what we've tried to do with our work around an accreditation program is to provide a uniform set of standards that ensure that an accredited entity across all markets nationwide actually has the infrastructure to comply with parity, and create market incentives where employers demand that, regulators demand it, and that there's a whole other set of levers that encourage these entities to voluntarily comply. And I'm hopeful that that will be more effective then enforcement will be in transforming the way this works.
So we could talk about this for a lot longer, I know, but at this point it's time for us to wrap up. So I'd really like to thank our panelists for their time today. It's been an excellent discussion. Thank you.